Yes, Dr.
Your
Dhawan?
Lordship wanted a list of the non-legislative functions of the state legislatures.
Yes.
Of course, the most important is democratic accountability. That's what the freedom movement was all about. From representative to responsible government. I made a note. Shall I pass it on and have it uploaded?
On what are the non-legislative functions?
Legislative function.
All right, because that is a question of the court, you can certainly
Because that's the question.
Yes.
From your Lordship.
upload. Kavita.
Can I hand it over?
Yes, put it as part of Mr. Yeah, can you ask a junior to email it, Dr. Dhawan, to the court master?
We do that. I'm obliged.
Give it to Mr. Prasanna and he will upload it
All right, no difficulty.
along with the extras of
All
some of the judges.
All right, thank you, Mr. Jaffer.
But proceeding on the premise that lordships have gone through the written
Yes.
submission, there is one apology that I have to make, but there is one serious error in that written submission. But wherever I have referred to Jammu and Kashmir, please read merger as accession, not merger, because lordship has seen Kashmir did not merge. So that's the error which I have committed, which I want to rectify it. Wherever I use the word in my written submission, merger in respect of Jammu and Kashmir, it has to be accession. I'll take just 2 minutes to sum up the context part which the lordships must have seen. Kashmir acceded differently because it acceded post August 47. The rest of the states concluded their accession as well as standstill agreement before August 47. Because standstill agreement was a precondition for instrument of accession. So they had all signed. Kashmir did not do it. And therefore, as per the cabinet mission memorandum 25th May, as well as the India Independence Act 1947, section 6 and 7 and 8, Kashmir acquired independence because the paramountcy ceased on 15th of August 47. That's the crux of the cabinet mission memorandum and the India Independence Act that follows it.
Yes.
The rest of the states barring Kashmir merged through agreements from time to time with the Dominion of India, ceding all their powers and sovereignty, barring Kashmir. And that is what lordship would notice in the instrument of accession. I would not take lordships through it, but that is what lordships notice. All the states were unqualified cession of sovereignty to the Dominion of India. Some ceded directly to Dominion of India states, Rajavans. Some ceded the Dominion of India while they merged with the provinces. Provinces lordship would know about the provinces under the Government of India Act, and they automatically merged in the Dominion of India. And some ceded to the Federation of States, the Union of States. But eventually, all these ceding rulers and states, Indian states, they accepted that their right to make constitution, which was guaranteed to them in the cabinet mission memorandum, and thereafter under the India Independence Act and the negotiations. They all ceded that Constitution of India will not be the sole constitution, with their constitution merging in the Constitution of India. And that is what is not the genesis of Article 238. Article 238 is significant, and this will answer one of your lordship's query, that what was the status of Kashmir when it ceded to the Dominion under Article 1 and the schedule.
Where will we get Article 238 actually? Where will we get the, because our constitution copy doesn't carry it, so if, I'll just check.
Not that.
It doesn't have in this, yes. I'll share it to Justice Court. Is it anywhere in the compilations? In the compilations, do we have it somewhere?
I have copies of this, but I brought copies of the.
Anyway, no, don't worry, we have it here.
You all rely heavily on Mr. Shankar. So very adept at these things.
Will
We are
the
not.
constitution as applicable to the state of J&K have that?
I'm sorry, no,
Will the constitution as applicable to the state of J&K have that? No.
no, 238 is in the Constitution of India.
And
So-
it can't have it because it's barred.
Yes, that's fine.
No, I'm coming to that.
B of the first.
I'm coming to that as a slight, something to be said. Lordships would bear this in mind that Kashmir ceded and became part of Union of India as Part B state. And all the ruler states were part of Part B state. I mean, they were all Part B in the schedule, first schedule. And therefore, 238 was made applicable to Part B states only, which were Indian states. Only what 238 does was, it keeps the promise of applying the state's constitution to the government, to the union, the Constitution of India. Part B state, 238 says that Part 6, 7, and consequently Part 11 will also apply to these Part B states. And that is how not all these Indian states merged unconditionally into the Constitution of India. Initially, all the Indian states were promised that they will have their constitution. But then through negotiations, this was taken out. My old vision was it.
Yes.
Now, the status of therefore Kashmir was of a Part B state in the year 1950 when the constitution was enacted. And yet, Lordship would notice in 370, Article 238 was excluded. That speaks volumes about the autonomy of the state.
Yes.
Therefore,
Just hand these up,
Are these given on a returnable basis or on a non-returnable basis?
That's what I got. In fact, when we were arguing Boileau's matter, we were looking for Article 31 and it wasn't in the footnotes. So when we conceived this constitution, we had to put all the old provisions. So
but the only discrimination my friend has is I have been.
You want me to have a later edition of this?
it's coming out in 3 days.
But the original, the intention to gift me was not there.
Attorney is very upset that attorney is being discriminated against.
No, you have mine, I have one.
Copy, I can
Ah.
turn it with my own copy.
My brother has his own copy.
I have my copy.
No, the Tony should be penalized for gifting us all. Now coming back to the number of this brief introduction was necessary because the basic theme of ours is that the Kashmir was entirely different, and this is what Lordship would notice in the debates.
It's all when it is open to the process.
Kashmir was different, both in respect of accession to Dominion of India when it ceded at a different point of time as an independent state or a nation. And it was different in the sense that it did not merge, unlike the other states, its sovereignty. And that is why the Lordship would notice in the instrument of accession, which was negotiated by Kashmir, the ruler. There are a couple of clauses which are not there in the other instruments of accession. Format is the same under 1936 Government of 35 Government of India Act, but the conditions which were added in favor of Kashmir were not there. For instance, we are not bound by any provision of the Constitution of India, future Constitution of India. The internal sovereignty rests in the ruler. The Union of India cannot acquire land in Kashmir. Kashmir would acquire for Union of India and give it. Now, from here, noticing these important issues, Lordships may just, I'd like to answer Lordship's query, which fell from one of the Chief Justice. The sovereignty aspect. And which eventually will answer not Justice Khanna's query also, the superior and inferior constitutions. Eventually. But the first aspect that we have to keep in mind is the sovereignty was retained by the Raja in the instrument of accession. Lordship has seen that, so I would not waste Lordship's time. The concept of sovereignty is a variable concept, Lord. Concept what it was in the 19th century, 18th century was no longer there in the 20th and 21st century. When the written constitution started coming and the democratization of autonomy, as my friend puts it, that's a very phrase pregnant with meaning. Democratization of authority and power, which is autonomy. The sovereignty being a variable factor has two components, the internal and the external, and there are two decisions which Lordship may just care to note. One is 1953. 1953, PEPSU, PEPSU, full bench, which deals with a similar situation where Patiala as an estate merged with British paramount still. Then what was the position of sovereignty of the Raja?
The page, Mr. Dwivedi?
Page 730. Okay, please listen to what I'm saying. Please listen.
You can give us page later, no problem. You can just have it.
739. 739.
739. What is the principle which it lays down?
I'm sorry, there is some 1953 PEPSU 1. But I'm sorry, this confusion arises.
No.
It's AIA.
Yeah.
Is it in any compilation?
Yes.
Case law compilation?
Yes. It says the sovereignty comprises of two parts. Mainly because you have ceded external sovereignty, defense, external affairs, and communication, it would not amount to ceding of internal sovereignty.
And what is the second judgment?
The second judgment note is a recent judgment, 2000, volume 8, SCC 61.
Can you repeat the citation, please?
2000, volume 8, SCC, page 61, paragraph 31 and 2.
Paragraph?
31 and 2. 31 and 30.
And where was this in the compilation? Where did you get it?
But I'm sorry, it's not there in the compilation because
It's easy.
later research not yielded all these results.
Page 61.
Given paragraph. And I don't have time. And the third judgment in this regard, which is a clear pointer towards where the sovereignty rests post-constitution, not the internal sovereignty. That is 59 Supreme Court, PN call.
KR 59 Supreme Court or?
PN calls case. No?
Oh, yes. That is case law compilation.
Page, volume 1, page 8. PDF page 8.
We have seen that, yes.
That's the situation with regard to sovereignty. You know? It's not that Kashmir lost all sovereignty merely because it acceded. And neither inclusion in the Article 1 and the schedule would result in loss of internal sovereignty. The key part of my argument is based on, and the key question which I'm raising is, that Article 370 ceases to operate once the Constitution of Jammu and Kashmir was enacted on 26th of January 1957. It is somewhat different from what most of my friends have argued. They want some part of 370 to survive post 57. My argument is nothing survives. All the powers conferred under Article 370, I would show would cease to operate once the Constitution is enacted. And in that context, we have to keep in mind the object of 370 and the commitments made by the Dominion of India then, and the approval of those commitments by the framers. But we must bear in mind that the people governing Dominion of India were mostly the same who were the framers of our Constitution. And they were wise men. We always say framers were most wise, dynamic, and sagacious. But then when it comes to the commitment made by them, we forget their sagacity. And therefore, I would pray, please permit me to place the debate of Dr. Iyengar, that is most crucial for my argument, and juxtapose it with 370, then I'll show one by one, all of the provisions become otious. So this is something which is a must for my argument, and I'll pray, please permit me.
Instead of reading, us reading now Mr. Iyengar's debate, his address, so we've read it 3 or 4 times. If you can cull out, and we'll take it down, if you can cull out what are the key parts of what he said, so that then we'll go on to 370.
Lord, the debate, if Lordship will see, the initial part says that Article 370, Clause 1, B1 and 2, these are provisions providing for consultation and concurrence of the government of Jammu and Kashmir. And it clearly says, debates clearly say, that this was an interim arrangement till the Constituent Assembly was constituted. Now, what does, with due respect, I submit not ask myself, what does this interim arrangement mean in respect of 1B1 and 2? If it was an interim arrangement, they said it is interim vis-a-vis Clause 2, which says, as soon as the Constituent Assembly comes into being, the final decision is that of the Constituent Assembly. With regard to A, the jurisdiction of Union and Parliament over Kashmir, and the Union's relations with the state, or state's relation, conversely, the state's relation with the Union.
So the first is jurisdiction of Union of India over Jammu and Kashmir. And second?
I'm sorry, but I can.
You said once the Constitution of J&K comes into being, the final decision
is that of the Constituent Assembly of Jammu and Kashmir, which was formed for framing of the Constitution. Clause 2 says.
On 2 aspects, you say. 1, jurisdiction of Union of India over Jammu and Kashmir.
And the center and the state relations. The finality would be that imparted by the Constituent Assembly of Jammu and Kashmir. I'll place only those portions not from the debate which not unerringly lead to that.
All right, let's quickly see those.
Yeah.
If you can just give us the page reference. वो अपना वो laminated दे दीजिए जरा.
Kindly come to note volume 5, PDF page 79. I'm reading Lord
Volume 5, page 79.
I'm reading the internal page 424.
We'll just go to that in a second.
I've not got it.
Just 1 second.
किसने पाना?
मिला दो.
In the page.
That is volume
Now,
5,
the
page
first part-
79. You're on the right document, but volume page 79.
The first part, of course, deals with the different situation of Kashmir, which resulted in this discriminatory treatment of Kashmir in favor of Kashmir. Then kindly come to the last paragraph. Last paragraph of that very page, no? Again, the passage begins like this, no? Again, the government of India have committed themselves to the people of Kashmir in certain respects. They have committed themselves to the position that an opportunity would be given to the people of the state to decide for themselves whether they will remain with the republic or wish to go out of it. That was the extent of right given. But let's keep that aside for a moment. Then last three lines of the paragraph, last 4 minutes, we have also agreed that the will of the people through the instrument of a constituent assembly will determine the constitution of the state as well as the sphere of union jurisdiction over the state. That's a very clear indicator. Sphere of union jurisdiction over the state will be determined by the Constituent Assembly. Lord, Lordships have gone through it, my friends skipped through it, but then the important aspects have remained uncovered. Therefore, I was. And kindly come to the next paragraph, which is even more significant. And this represents clause 1B, 1 and 2. At present, the legislature, which was known as Praja Sabha in the state, is dead because the situation was such in Kashmir at that point of time, nothing could be functional. Neither that legislature nor the Constituent Assembly can be convoked or can function until complete peace comes to prevail in that state. We have therefore to deal with the government of the state, which as a representative, as represented in its council or of ministers, reflects the opinion of the largest political party in the state. Till the Constituent Assembly comes into being, only an interim arrangement is possible and not an arrangement which could be brought into line with the arrangement that exists in case of other states. Now, the word interim arrangement follows their elaboration that neither the Constituent Assembly is convoked nor the Legislative Assembly is there under the 39 Constitution, which is Praja Sabha. Therefore, whom should we consult? We are forced to consult or get the concurrence of the government, which is the only representative body, till the Constituent Assembly comes. This leaves no room for doubt. With regard to 1B1, 1B2, and even 1D, I'll show. All those provisions which provided for consultation and concurrence with the government of India, government of Kashmir, cease to operate till the, operate only till the Constituent Assembly is not there. No sooner it comes into being, it ceases to. Then Lord, the next paragraph, which is a short paragraph, further corroborates that impression. And it further indicates that 306A is also a temporary provision. Not all this argument, not that has become permanent. We are giving meaning to the word temporary used in the constitutional provision. What's the context, the object? Please have this. Now, if you remember the viewpoints that I have mentioned, it is an inevitable conclusion that at the present moment, we could establish only an interim system. 306A is an attempt to establish such a system. Now, what else does temporary provision mean? It's an interim provision. They're saying it in so many words. And yet, what we are trying to do is make it permanent, changing the entire text of the Constitution. No, 306 lordships, no. Here, I mean, sorry. for a second, Lord. The Constituent Assembly is always regarded by us as the most august assembly ever in the history of our assembly, and they evolved the Constitution. They were men who fully knew what Constitution means. When they say, the Kashmir would frame its own constitution, they could have not implied anything else except what they were doing.
All right, we now take this point of yours based on those two extracts from Mr. Gopal Swami Iyengar's speech. Now, you want to refer to further something here in his speech?
Yes.
All right.
Kindly have not omit the next paragraph, Lord. That is 238, so I've already elaborated. So,
Yes.
Then come not to the next one, not the paragraph. The second portion of this article relates to the legislative authority of Parliament over the Jammu and Kashmir state. This is governed primarily by the instrument of accession. Broadly speaking, that legislative power is confined to three subjects of defense, foreign affairs, and communication. But as a matter of fact, these broad categories include a number of items which are listed in the instrument of accession. I believe they number some 20 to 25. Now, these items have undergone a change in the description, in numbering, in arrangement as amongst themselves in list 1 and list 3. But this is the justification of putting list 3 in 371B. Now, these items, it is therefore necessary that the items mentioned in the instrument of taxation should be brought into line with the changed designation of the entries in list 1 and 3 of the new constitution. So clause 1B of article 306A says that this listing of the item as per the terms of the new constitution should be done by the president in consultation with the government of the state. Then kindly come to clause B2, that is for concurrence. Clause B2 refers to possible additions to the list in the instrument of accession, and these additions could be made according to the provisions of this article with the concurrence of the government of the state. The idea is that even before the Constituent Assembly meets, kindly notice again the same thing comes. The idea is that even before the Constituent Assembly meets, it may be necessary in the interest of both the center and the state that certain items which are not included in the instrument of accession would be appropriately added to the list in that instrument so that administration, legislation, and executive action might be furthered. And as this may happen before the Constituent Assembly meets, the only authority from whom we can get consent for the addition is the government of the state. Now, if I will not read this and if I draw an inference from this, the only inference is that even B2, for all those provisions where concurrence is required of the government or consultation is required of the government, for adding anything to the instrument of accession, whether in terms of list items or in terms of other provisions. All the provisions of consultation and concurrence were interim till the Constituent Assembly meets. This
Deveri, just also read the next clause. The last clause refers to, and thus the Constituent Assembly, when it is referred to in the last sentence of that clause, is an indication that the Constituent Assembly may continue. It's at page 427, internal page.
No, I'll come to that. Please bear with me. No, I'll explain that. I'll explain. I have that in mind. I'll bear.
And whether the Constituent Assembly, when used in the last sentence of that paragraph,
yes,
will be in the indication that probably the Constituent Assembly over here was meant to get prolonged also.
I'll answer that. Then, having seen this, that the consultation and concurrence were only for a temporary period till the Constituent Assembly comes into being. And that is what Lordship may now fall back on the Article 370 Clause 2. 370 Clause 2. No, but this submission of mine tends to show to your Lordship's note that both the provisos again provide for consultation and concurrence. Because they govern clause 1B to 1D. And therefore, no sooner the Constituent Assembly, as per the intent of the framers, comes into being, they would continue to operate because that's the only agency left for consultation and concurrence. But once it comes, then the consultation and concurrence has to be with the Constituent Assembly. That is what clause 2 says.
Mr. Dwivedi, I don't want to rush you. We started at 10:40 today. The time allotted to you is till 11:25. We are now about 11:12. So everybody will have to stick to time today. So,
Lord, I'm obliged, Lord. Lordship has granted me this much of time, but please bear in mind, if I'm saying something which has already been said, Lordship may stop me. But if there's something which perhaps is new or different.
all that I'm saying is we need not read now the rest of Mr. Iyengar.
I'm not. No. But the Iyengar statement is relevant because it answers the Lordship's query as well as not the inferiority and superiority of the Constitution of India. Also, I'll show.
That
So
speech we have
according
read at least twice, thrice.
I will.
That speech we have read at least twice, thrice before.
But your contention really is that once the Constitution of Jammu and Kashmir was framed on 26th of January 1957, the entirety of 370 ceases to exist.
There's nothing left now.
And then the only governing document is the Constitution of Jammu and Kashmir. We got the point because they'll have to answer that.
We cannot ignore the fact what was the commitment made. When we see 370, it has to be in the light of the commitment made to the people of Kashmir.
Now, Mr. Dwivedi, can we go to Article 370 because we would like to dovetail this speech with 370.
Extremely obliged. Kindly have Lord 371.
371, yes.
A. First, the heading is temporary provision. Under the heading temporary provision.
Which are the features of 370 which according to you would indicate that it would cease to exist after the Constitution of J&K has been framed? Which are those? You can just identify them.
If we read the debates and dovetail it over here, it will be apparent.
Yes.
Not 238, the provisions of 238 shall not apply in relation to the state of Jammu and Kashmir. This provision has ceased to exist in the Constitution of India from 1957 onwards. But it has not been changed for the reason that there is no power to change it. Clause 3 requires Constituent Assembly, Clause 2 requires Constituent Assembly. And therefore, what my friend was right, Dr. Dhawan, when he said 52 onwards, Clause 3 has not been used. 238 is an amendment to Article 370, therefore Clause 3 was the only provision available. And it has not been used, and it is allowed to exist because there is no way you can change it.
Because for 370, you have to amend 370, you have to fall back on clause 3.
Yeah, they have to. But they can't because the precondition for exercise of power is there. Now, Lord, kindly have Lord B, 1B1. That is a one-time power, Lord. There's no dispute about that. Once you determine which are the entries relating to instrument of accession, power ceases to operate. But yet it continues. No one has deleted that. Again, the same logic. Then comes 1B2. Such other matters in the said list, with the concurrence of the government of India, not government of Jammu and Kashmir. Now, reading the statement of Dr. Iyengar, which I placed for much. This is an interim arrangement because at that point of time, there was no other authority to consult or concur. Until the Constituent Assembly comes into being. And that is why 2 comes in. Lord, even I'll go to the extent of saying, Lordship would see logically clause C also ceases to operate. Article 1, it says the provisions of Article 1 of this Constitution shall apply in relation to the state. Reason being, Lord, 370, Lord, when the Constitution comes, it itself says we are inalienable part of India. And for the federation purpose, Article 1 was there. So we can read both the statements together. There is really no need to go fall back on C. Lordship has seen, Lord, Section 3 of J&K Constitution, including the preamble, loudly pronounces them. We are inalienable. And this provision, Lord, Section 3 cannot be modified under 147, Section 147, which is the mandatory power of the Constituent Assembly. It's a basic feature of that Constitution, therefore, which is not prone to amendment. That position is settled. Now comes Lord D. Such of the other provisions of this Constitution shall apply in relation to that state, subject to such exceptions and modifications as the President may by order specify. Now this, Lord, immediately refers to the second proviso. First proviso I have already shown is the same thing as 1B1, where the word consultation and concurrence itself is embedded in the provision. So it's more or less reiteration of that. Second proviso says, no such order which relates to matters other than those referred to in the last preceding proviso shall be issued except with the concurrence of the government. And Lordship has seen, Lord, the very initial part of the concurrence and consultation was brought in only because there was no other authority. And therefore they said until the Constituent Assembly comes into being. So therefore, in my opinion, Lord, humble opinion, subject to what Lordship decide eventually, even 1D becomes ocious. That power cannot be exercised because the concurrence now has to be by the Constituent Assembly. It cannot be, and that is what T2 says. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second proviso to subclause D of that clause be given before the Constituent Assembly for the purposes of framing of the Constitution of the state is convened, it shall be placed before such assembly for such decision as we take. Therefore, even the concurrences and not the consultations that have resulted into something, the finality of decision is vested in the Constituent Assembly. It can overturn that concurrence. And that is what the framers say in respect to clause 2, that the finality for determining the status of union and the state relations, as well as the jurisdiction of Parliament, rests in the Constituent Assembly, who will finally determine these things. Well, Constituent Assembly would finally determine through the shape of Constitution of Jammu Kashmir. It can't finally determine otherwise. Final determination has to be the enactment of Constitution, which was done. That is why I wanted to place the other paragraphs now, where they have said this in so many words. The final determination would be that of Constituent Assembly in respect of parliamentary jurisdiction over the state and the union's relations with the state.
Clause 2 does not give finality to the decision of the.
I'm not saying, as I said, please juxtapose the provision with the debate, and the debate says that.
So in other words, we'll be reading an ingredient of finality from the Constituent Assembly debate.
But I'll ask myself.
How can that be?
If the debate says that's the commitment, because Jammu and Kashmir Constituent Assembly will determine the constitution. What is the use of the commitment not made, and what is the use of the constitution when it cannot finally lay down anything? Just look at it this way, Lord. Unless we see 370 in the light of the commitment made, and the commitment was to framing of the constitution. But
Can we say that a speech or an address made by an individual member of the Constituent Assembly, however weighty, represents a commitment by the nation or the Dominion of India to the state of Jammu and Kashmir? This would have a bearing on the interpretation of the constitutional
my answer
provision.
to this is not when we try to see.
But for us to raise it to the point where it's a binding commitment, a speech by a very distinguished member of the Constituent Assembly represents a binding commitment of a nation.
But that statement is not by any member. That was a statement on behalf of the person who answers all the queries on the amendments made. That's a difference.
Severi, what you're asking us to read into it is something which is not there in the article. But if the article was that this article will get frozen in point of time after the Constituent Assembly of JNK frames the constitution, that doesn't appear to be following. Because that's why I said come to page 427, and that makes it very clear. Because you are reading, we can't read a portion of the debate without going through the entire.
Your Lordship
what
is
has
reading
been
the
said.
last paragraph and I'll explain.
Not the last, yes, the last claim, the last clause.
The
Just read
effect of
that.
this article.
Yes, just read that. You can't
The
read,
effect-
because you can't read portions, dehouse the other, because when this debate is going on,
Fine.
there can be statements and then the explanation to those statements.
Now, Lord, may I answer it in this way?
And the other part is, you see, once you become a part of the nation, become part of it's the entire nation then you are part of.
This is what is creating a problem, Lord. Are perhaps thinking in the manner which we have been tuned to think for last 70 years, Lord, is that one nation, one constitution. But where is that prescribed, Lord? I ask myself. Accepting it could be prescribed in the Constitution of India, but Constitution does not say so.
Anyway, just read that paragraph.
And the effect of this article is that Jammu and Kashmir state, which is now part of India, will continue to be part of India.
No, the one before that. The last clause refers to what
Right.
may happen later on.
The last clause refers to what may happen later on. We have said Article 211A will not apply to Jammu and Kashmir. This is Article 238. But that cannot be a permanent feature of the constitution of the state, and hope it will not be. So the provision is made that when the Constituent Assembly of the state has met and taken its decision, both on the constitution of the state and on the range of federal jurisdiction over state. Can you notice that? State, the president may, on recommendation of the Constituent Assembly, issue an order that the Article 306A shall either cease to be operative or shall be operative only subject to such exceptions and modifications as may be specified by him. Now, Lord, I ask myself this question.
Just read further in the last paragraph there.
But before he issues any order of this kind, the recommendation of the Constituent Assembly will be a condition precedent.
Correct. Now read the next paragraph also.
Very well. The effect of this article is that the Jammu and Kashmir state, which is now part of India, will continue to be part of India, will be a unit of the future Federal Republic of India, and the Union Legislature will get jurisdiction to enact laws on matters specified either in the instrument of accession or by later additions with the concurrence of the government of the state, and steps have to be taken for the purposes of convening the constitution. The Lordship may not detach one line before the succeeding line. It says concurrence of the government, and then effort should be made to establish the Constitution of India. So this is what, I mean, the Jammu and Kashmir, the Constituent Assembly. Now, Lord, if your Lordship would read it with the first part and this part, Lord, after all, this they are elaborating. So we can't detach the first part from the last part. So we are not, with due respect, Lord, we cannot snatch away this part, Lord. Steps have to be taken for the purposes of convening the Constituent Assembly in due course, which will go into matters I have already referred to In other words, Lord, all this is talking again of that interim period. The concurrence, and otherwise, Lord, the first part says concurrence ceases till the Constitution comes into, Constituent Assembly comes into being. And if we read later part as saying that no, it will still continue, that there's a contradiction to that, Lord. And therefore, Lord, my cohesive reading shows that perhaps when they gave this, this power of consultation and concurrence to the government, it was in a peculiar situation, not beyond that. And that is the key. As I said, that was the key to indicate what was the scope of 1B1 and 1B2, including 1D, the two provisos. And it's nobody's case, 2 and clause 3 survive beyond 1970, 57.
After the Constituent Assembly took its decision on 26th of January 1957, the Dominion of India would have no power to apply any other provisions of the Constitution to Jammu and Kashmir.
They have all the powers. As I said, if your Lordship would see the 44th Amendment, which is the basis for Constitution of Jammu and Kashmir. That gives Union of India all the entries which it has under the Constitution of India, 1 to 96. Excepting 97 is not there because residuary power is there with the state. Section 5. That was I'm not here to judge whether they were right or wrong. I'm here only indicating to your lordships that this is one of the intents clearly falling from the interpretation which they had given to 370 only. And we have always argued, we have always said, look into the debates to cull out the intent of the provision. So all that I'm saying is kindly look into the debates to cull out the intent of 370. And when we see the debates along with 370, it clearly emerges that this power is not available thereafter. And that is where I submit with respect, Lord Sampath Kumar is wrong. Lordship, I have indicated in my written Sampath Prakash. And the biggest mistake committed by Sampath Prakash, if Lordship would see, is they relied upon 1952 presidential order, which incorporates, that's the explanation. If Lordship would see 370 explanation, that was what was incorporated by Sampath Prakash, modified. Initially, it was the dynastic rule that the president will recognize the Raja as Sadr-e-Riyasat. But 52, the Constituent Assembly moved a motion and abolished this dynastic rule and said now Sadr-e-Riyasat would be elected by the Assembly or on the advice of the government of Jammu and Kashmir. Now, this was sent to the government of India with the concurrence of the Constituent Assembly under clause 370. And it was incorporated in the form of an explanation to 1 that Sadr-e-Riyasat would be. Now, the Sampath Prakash assumes that this 52 order, continues the Sadr-e-Riyasat, and therefore it shows that they wanted permanence to 370. But they erred in one respect, and something which was not pointed out to them. Kindly have section 27 of the Jammu and Kashmir Act.
Dwivedi, your submission is that defunct provisions of the Constitution, 370 was a defunct provision of the Constitution. No purpose in having it there, yet it continues to be there. Everything would be determined by J&K Constitution.
I'll answer that.
COs have been issued from time to time, pre-57 and post-57.
I'll answer.
And yet, nobody thought about it. Yet the so-called affiliation with 370, a section of the people feel was also negatory because nothing survived.
Lord, may I please permit me to answer this
difficult to go
which
that
has
far.
fallen from your lordships, not that the past practice is going to justify the invalidity of that.
Past practice.
That's not the law. Laws, as I understand, is howsoever long the past practice may be, if it is constitutionally illegal, then it cannot be justified. And I'll show, here kindly have section 27 of the Jammu and Kashmir Constitution. It is volume 20. Not howsoever much we may not like it, no, we may not approve it, but the fact remains, all that I'm trying to show is the intent. And should we read Article 370 was the intent? No, that's my question.
We read an intent based on the constitutional law debates according.
But
How it transpired after that, how it has worked out is, you say, irrelevant completely.
That's why I said not any amount of illegality or action that may have been taken subsequently cannot justify the invalidity. Once it is, I'll show.
Yes, what do you want?
Questions can never be not the.
Which volume do you want us to see now?
Yes. Kindly have not volume 20.
Page? What page would that be?
PDF page 310.
Page
310.
PDF page not 310. But I know, Lord, I'm advocating a cause which may not sound very. I mean, in fact, which may not sound.
No, it's not that. It's not that. Please.
I was conscious of it.
I know. You see, the explanation which was added in 1952 refers to the Council of Ministers.
I'll answer that.
It refers to the,
27.
but it doesn't refer to the Constituent Assembly.
It does.
And it doesn't refer to the Constituent Assembly. Explanation. And it defines the expression government of the state for the purpose of that article.
Yes.
It defines the expression government of the state for the purpose of that article.
And that is with the concurrence of constituents.
And there lies the distinction between the Constituent Assembly debates, because Constituent Assembly debates are not relevant as far as the explanation is concerned.
That's not correct. That's what I'm saying. Kindly have section 27.
What
This
finding-
Sadr Riyasat in that form continued under Constitution of Jammu and Kashmir.
One thing I'm finding difficult to accept, you
Man.
persuade, is that.
I know, Lord, it is difficult.
No, I'm saying so that the Constituent Assembly debates amounted to an assurance that 306A or 370 would dissolve itself.
I'm not saying that.
And whether after that it did or not, it has dissolved itself.
No, that's not right way of putting my question. Not my answer.
If you say 370
No,
is
I'll
the
answer that.
statute, then it dissolves. It's
No, what
automatic.
I'm saying is, what I'm saying is, Lord, debates indicate the intention behind 370 and the scope of 370. Because it's very common, Lord, every time when we see this, want to investigate and go into the question of intention of the framer.
I thought you said 370 doesn't exist. According to you, it's only on paper. It doesn't.
Post 97, post 57.
Yes, yes. So I am saying what you say is the constitution debate should be read in a manner that 370 was intent to dissolve itself on the Constituent Assembly completing the JNK Constituent Assembly completing the process.
No,
and it has inadvertently remained on the statute, over which some people seem to be very, let me say better words, feel very strongly about 370.
Fair enough, my lordships. Just say lordships would have
I am
their
putting to you the
opinions,
consequence. I am putting to you the consequence. What would happen were we to accept what you are saying?
But
this is what I'm only trying to put it
But
in
I
perspective.
ask myself, Lord, I don't feel that there would be any adverse consequence. Lord. Once we accept, please keep this in mind for a moment, Lord, that yes, two constitutions could have separately existed cohesively. Lord. But what will be the consequence? I ask myself. Lord. And that was the intent of the framers, and they felt, Lord, eventually Kashmiris may agree to something which is like other states, but then they didn't enforce that. They still permitted constitution to be framed. But constitutions are not made for a day, lordships have held in 2018. They are made till the lifetime of the state or the nation. They're not made for a day or two. They can't be held to be an interim measure, to be chipped off and on. Now, please have 27. What the Supreme Court in Sampath Kumar overlooked was that explanation did not continue. What continued thereafter was 27 section.
The net consequence would be that the Constitution of India, in its application to the state of Jammu and Kashmir, would stand frozen as of January 1957. Therefore, no further development in Indian constitutional law can at all apply, according to you, to the J&K
Exactly.
the state of Jammu and Kashmir after 1957.
Because Constitution of Jammu and Kashmir
How
itself,
can that be acceptable?
we may ask this question how, but the question is which provision of the Constitution permits that except 370? Now, if I am right in my submission, the 370 ceases to operate. then which other provision would
But
take
if
away?
Article 370 ceases to operate and Article 1 continues to operate, and then Jammu and Kashmir is an integral part of India, surely the jurisdiction of every democratically elected institution in India is not excluded in its application.
What I'm saying here again, let me reiterate.
There has to be then a provision in the Indian Constitution which excludes its application to Jammu and Kashmir, and there is none then according to your argument.
This may be our wish, but the point is, let us look at the provisions of the Constitution. This is what I'm saying.
So Deveri, in fact,
70.
in fact, your argument now cuts across the other side argument.
That's right, no? They
Your side argument itself. You're cutting, you're cutting at,
no, but
you see, and,
there's a difference.
and just look at the second proviso. Just turn to the second proviso.
Yes.
Except with the concurrence of that government. Now, the government has been defined, and the argument of your side, some of your colleagues on your side, is government, and the government of the day, council ministers, is different from the Constituent Assembly and the Legislative Assembly.
No, this is where
And here, the second proviso does not use the expression Constituent Assembly. It says except with the concurrence of that government. And government has been defined by pursuant to the amendment in 1982. And therefore, your challenge or to the dictum in Sampath Kumar is slightly, gets into difficulty. Because that's the intent behind it.
May I answer that? No? When it says that government, what it means is the government which was preceding the Constituent Assembly.
That's
It can't be any other government because then
that's contrary to the explanation.
I'll answer. But kindly bear with me. Why do I say so? After second proviso, there is clause 2. And what does clause 2 say? Whatever concurrence has been given prior to Constituent Assembly has to be placed before Constituent Assembly for enabling it to take a final decision.
What it means is this, that if there is concurrence, because initially when the Article 370 was there, it was Sadr Riyas and the other council. After that, at that time, if any decision is taken, it will be with that.
Sadr Riyasat continued.
I know, I'm aware, but the explanation which is added is with regard to then the Council of Ministers. The explanation in 1952, which was added by the concurrence of the Constituent Assembly, was with regard to the Council of Ministers.
So there's no difficulty, Lord. We are reading little, with due respect, Lord, we're reading little too much on that. Because have section 27 to 32. It is the Sadr Riyasat elected by the Legislative Assembly who will be the Sadr Riyasat. And obviously the recommendation goes through the Council of Ministers, not otherwise. So the Council of Ministers and Sadr Riyasat as well as Legislative Assembly are all there, elected. And then not by explanation, relying on the explanation to 1952 order, he cannot say in 57, Lord, Constitution does not seize 370, Lord, that doesn't follow because Constitution includes Sadr Riyasat. The continuance of Sadr Riyasat had to be as per section 27, it couldn't be, and that was the fact. So this assertion in Sampath Kumar, relying upon the 52 presidential order, adding the explanation of elected Sadr Riyasat is not correct. Lord, there are lots of misconceptions. For instance, Lord, in Damanu's case, which I think one of my friends may have cited that. Lord, please read clause 2 in the debates, Lord. Please read clause 2 in the debates, Lord. Lord, may I pay here? Lots of clarification would be there if your Lordship would read the explanation to clause 2 in the debates, Lord. Page 427, the same page. Page 82. Then we come to clause 2. The passages, Lord, paragraph. Then we come to clause 2. You will remember that several of these clauses provide for concurrence of the government of Jammu and Kashmir and the Jammu and Kashmir state. Now these relate particularly to matters which are not mentioned in the instrument of accession, and it is one of our commitment to the people of people and the government of Kashmir that no such addition should be made except with the consent of the Constituent Assembly, which may be called in the state for framing of the Constitution. In other words, what we are committed to is that these additions are matters for the determination of the Constituent Assembly. That explains Lordship's question. It may be 1, 2, second explanation, but it comes before clause 2. After reading the explanation in the clause 1B2, 1D, they come to clause 2. Not otherwise, not the whole reasonable not the sequence denoted in the Article 370 has no meaning then. And this note paragraph includes the second proviso. Clearly. So inferring something different from that word, that government note, to me, Lord, as I see it, it doesn't follow. And then also the next paragraph is equally, so far as the other thing is concerned. Yes. Just one paragraph. No? Now you will recall that in some of that has been done. That we have read. We have read. As I said, Sampath Kumar was not, Prakash was not rightly decided. And if your Lordship would just have a look at Sampath Prakash, that perhaps may eventually conclude my argument. Sampath Prakash is?
Which is the provision of the J&K Constitution equivalent to Article 245 or 246?
They have their own Section 5, which defines the powers of both state and indirectly the Parliament. Section 5 will also have. And this is what continued for a long period of time. If practice is relevant, then this is continued for a long period of time till this order comes. And you have Section 5. That is for lots of convenience, volume 2, PDF page. I mean, first refer to the preamble.
Now see the problem with your argument, because Article 5 says that the legislative and executive power of the state would extend to all matters except those with respect to which Parliament has power to make laws for the state.
Yes.
Under the provisions of the Constitution of India.
Yes.
Therefore, that takes us to the Constitution of India.
No, the reason being
that therefore postulates that the Constitution of India does apply to the state of Jammu and Kashmir.
That overlooks one important factor. And that is the 44th Amendment immediately preceded with the concurrence of Constituent Assembly, where they had elaborately defined what are the provisions of the Constitution of India would be applicable to Jammu and Kashmir. And this Constitution is elaborately based on that 44 order. And therefore, it presumes whatever power has been given to the Parliament under the scheme of things, 44, there what they have indicated is entries 1 to 96 of list 1.
But unless for the purpose of the argument of this side, unless we accept that Article 370 did continue until 2019, there would be absolutely no trammel on the jurisdiction of Parliament under Section 5.
As I said,
because 5 says except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution.
But there's not
now, under the Constitution, but for 370, Parliament would have the power to make laws with respect to all aspects in List 1 and List 3. Now, if your argument is that 370 goes,
the moment we come to
then where is the limit on the power of Parliament?
I'll answer. It has, Parliament has power to make laws. Now let us fall back to that stage. What was the power given to Parliament at that point of time to make laws? The 44th presidential order, 48th presidential order, which is 1954. it elaborately determines what is the scope of parliamentary jurisdiction, that is entry 1 to 96. Now, if we add entry 97 to that, again, because that is Parliament's power, then what will be the fate of section 5?
But then you've been arguing all this while that these constitutional orders are a matter of constitutional practice. They're contrary to the provisions of they're contrary to the constitutional provision. If we accept your argument and therefore don't look at the constitutional orders, then this is the consequence which follows as a sequitur of your argument, that there would be no restraint on the power of Parliament then.
The sequitur is this, Lord, that after the 1954 order, there couldn't have been any other order. And that is why they say in respect to which Parliament has power to make law. Otherwise, not again, I fall back on the same theory. Internal sovereignty continued with the state. The constitution ensures that internal sovereignty, there is not the whole legislative provision, the executive provision, and the judicial provision. What is the utility of that, Lord, if 370 continues to infiltrate? As I said, Lord, add entry 97, that is the residuary power. Then what remains of this? And yet the commitment was there. Not all that I am suggesting time and again is see it in the light of the object of 370, the intent. The object of 370 was only to ensure that no one from outside interferes with the constitution making. That was the object of 370 as the framers have delineated. So therefore, Lord, otherwise, Lordship may see 254 doesn't apply.
Dwivedi, now I think we've really understood your perspective. Can we now wrap up?
Yes. So Sampath Kumar, I've already indicated.
You've already argued Sampath Kumar. So we'll now, there's some people who have to follow now.
It is wrong.
Thank you so much, Mr. Dwivedi. Thank you very much.
No, there's one aspect which I want to throw light on, which fell from Justice Coleman. But since there has been repeated exercise of power since 1957 onwards, under 370, therefore that speaks of the validity too. We have to take that into consideration, if I have understood rightly. It can't be that the power was not there yet it was being exercised. Now, there are two authorities which I cite here. And one is which we could call out, because the argument fell from your lordships. Your lordship would permit me. What Sirvaya has to say on that?
What is the proposition you are seeking to
The
make?
proposition is that howsoever long the practice may have been, acquiescence, howsoever long it may have been, that will never confer validity on the provision if the power is not there.
That may be, what has been put is not in that fashion. What has been said is if there are two interpretations which are possible.
No, not that. I'm not.
That's what was put to you.
What is being put is the way it has been understood by everyone.
No, as I said, not if two interpretations.
Now, at this stage, you say, no, all that has happened over the last so many decades is wrong. Nobody understood the constitution of JNK, nobody understood the constitution.
That's what lordships did in Lord Golaknath.
Said.
That's what your lordships did in Indira Sahni. But in Indira Sahni, so please recall what happened in Indira Sahni.
All right, we've taken the point that the constitutional practice will not legitimize a constitution.
That will not legitimize.
Fair enough. Thank you, Mr. Dwivedi. Thank you very much. We'll now go on to the next, Mr. Singh. Yes, Mr. Siv Singh now.
But there is one decision that we'll just make a note of it.
Yes.
1961, Supreme Court. AIR 1961, Supreme Court, 964. Para 1 and 2.
964.
What is the name of the case?
This is Amalgamated Coalfields Limited. So just two paragraphs. No?
All right.
1 and 2. It's a constitution bench. Again, they said these are questions cannot convey any kind
Thank
of
you, Mr. Dwivedi. Yes, Mr. Singh.
And all that I'm saying, Lord, if two views are possible, let's take the view in favor of the Constitution of Jammu and Kashmir. The autonomy which we had promised, the commitments made.
Thank you, Mr. Yes, Mr. Singh. Thank you, Mr. Dwivedi. Yes.
I'm
Mr.
obliged. But I hope I have not ruffled too many
No,
feathers.
not at all. It's an intellectual exercise, Mr. It's a debate. I mean,
The debate, therefore, we will give our perspective of what we perceive where the debate may be going, so that you have a chance to, clarify to us. That's all. Otherwise, as I always say, simplest thing is to keep silent. But that's not good for the lawyers.
Questions are put to get an answer. It's not the conclusion. Questions are never the conclusion.
thank you, Mr. Dwivedi. Yes, Mr. Singh.
Just take your iPad. I must say it's been one of the highest intellectual debate that we have seen for a long time. But we are all grateful to your
Thank you, Mr.
taking it to that level.
Thank you, Mr. Dwivedi.
Nobody has misunderstood your lordship's.
Thank you, Mr. Dwivedi.
Please be rest assured. It's been a privilege for us.
Thank you, Mr. Dwivedi. Likewise for us also, it's a
We've got some
Share,
excellent assistance and various nuances of the Constitution from all of you.
it's really, the bar has taken the jurisprudential analysis to a different level. And I'm sure we'll be hearing more of it from the other side now after we conclude today. Let's see. Thank you very much. Yes, Mr. Singh.
I took your lordship's the suggestion which fell from the court at the case management hearing which took place on 3rd July. I took that very seriously. I consulted my colleagues, and I am concentrating only on the State Reorganization Act because Article 370. I'm adopting the argument. My written submission also I've noted. I've adopted the arguments of Mr. Raju Ramachandran because they were available at that time, and of Mr. Gopal Shankar Narayan, the written submissions on 370 and the abrogation and all those aspects.
Now, Mr. Singh, can you just formulate what your submissions on the Reorganization Act are going to be? If you can just, we'll take it down.
Your Lordship, they are broadly in my written submission, but there are some nuances and finer points which I have to, which I'll place before your Lordship. Broadly, it is this, Mullah. First of all, the proclamation, the presidential proclamation of 19th of December 2018, paragraph C2, Roman 2, is void. And that is the one by which the two provisos to Article 3 was suspended. The two provisos which applied to Jammu and Kashmir in Article 3 was suspended without even concomitantly applying the proviso which exists for the rest of India. That's number one. I'm just formulating the proposition.
Yes, one second.
That being void, on the 5th of August and 6th of August 2019, it is my submission that the two provisos applicable to Jammu and Kashmir were very much have to be treated as being in force. Two is that I'll hand across a one-page timeline. The timeline of how the resolutions and amendments were executed on the 5th and 6th of August 2019 shows, Millards, that there is absolute legislative legerdemain, something which is, it boggles the imagination. I'll show your Lordship that neither the Constitution of India nor the Constitution of Jammu and Kashmir are applied, and what is done is just by a sort of sleight of hand. It'll become. I don't want to.
How would you formulate the second point? The first we got that the proclamation.
I'll just place that before your Lordship. But what I'm saying basically is
conceptualize it so we can just.
The point is, Millards, that the CO 273, which comes to be issued on 6th August, is in a sense applied in anticipation. A bill is presented by. I'm only on the Reorganization Act now. The bill for reorganization is presented by the President, tabled in the Rajya Sabha, passed by Rajya Sabha on the 5th of August, then tabled in Lok Sabha on 6th of August, and simultaneously with the recommendation of Lok Sabha to the President to issue CO 273 But simultaneously, even before 273 has been issued, Lok Sabha passes a bill which is purportedly passed by the Rajya Sabha the previous day. I'll just make good the proposition. I'm just outlining it. So what happens ultimately?
You just said what is the proposition? That they dovetailed and managed the time in a manner, everything occurred within this 2 days' time. But we wanted to know what is that you're selling?
The point is that the provisos which are in place and the explanations, the two explanations, which are in Article 3, the two explanations were not applicable in Jammu and Kashmir because the 18th Amendment was never extended to Jammu and Kashmir. So the explanation which said that it's a union territory, the argument is that we can interchange states and union territories under Article 3 because of the two explanations which were introduced by the 18th Amendment. That was not applicable to Jammu and Kashmir on the 5th of August. So as far as Jammu and Kashmir is concerned on the 5th of August, it was only a state. Any changes under Article 3 could only be state to state. But I'll come to it. I'm just formulating the points. I'll hand across this. Now, dehors this aspect. My submission is that Part 1, that is Articles 1, 2, 3, and 4, have to be read conjointly. And when you read them conjointly, no power can be found in Article 3 to convert a state into a union territory, notwithstanding the two explanations which are added by the 18th Amendment. Four.
One second. Yeah. 4 or 5, because I might lose track because it's all oral. It's 4. It was that if two interpretations were possible as far as Article 3 is concerned, then that reading should be preferred, which would be in keeping with the principles of federalism, the principles of democracy, the principles of the representation of the people of a state, and which would keep Article 3 out of conflict with Article 368. That reading should be preferred, and not a reading where Article 3 is allowed to ride roughshod, coach and horses through Article 368 without any of the safeguards introduced in 368. And this, Lord, I'll show your lordships, not just from the constitutional reading, but from the history of the article, Article 3 and Article 363, 4, that is 1 to 4, but 3, 4, and Article 368, and the view taken by your lordships in certain judgments, as well as Dr. Ambedkar's speech on Article 304, which was 368. That there has to be a harmonious construction between these articles, where that article 3 and 4, which allow an amendment to the constitution, but by a simple majority in parliament, can't impinge on those amendments which have the effect of either which attract the proviso to 368 or which in any case require a special majority by their very nature. Will you be referring
So
to
the
text of the constitution for developing an argument? How
Yes.
should we now go about it? We made your 4 points. We made a note of the 4 points.
No, there is a little more here. So these are the broad issues. There might be some finer points. So let me just start straight away with, and I'm going to try to be brief, but I just want to preface it by saying that since I had confined myself to this subject, several of Mr. Kapil Sibal, Dr. Dhawan, etc., all touched on Article 3, but they made it clear that they're leaving it to me to argue this.
So let's see Article 3
So I'll ask for some latitude from your lordship on time because of this. And I believe that the Reorganization Act, apart from 370, is very, very important for the people of Jammu and Kashmir. And also that if this interpretation of Article 3 were to be upheld by your lordships, then this is the thin end of the wedge for democracy and federalism in the country as a whole. Because any party in power at the center, if it also happens to be the party in power in a given state, can just convert that state by a simple majority in the state legislature, and a simple majority in parliament can convert the state into a union territory. This is a proposition of course of action.
Let's see Article 3 now.
Which is fraud. I'll come back to Article 3 in a moment. First, I'll go see,
yes,
the same
certainly.
sequence. So first, para C2 of the presidential proclamation.
Where would you get that?
In volume 3, page 92 of the document, volume 3 of the documents. Page 92. Lord Chizalda? This is expressly under challenge in at least 4 of the petitions. And Mr. Raju Ramchandran's written submissions open with this also. So if we come to C straight away, now therefore I hereby proclaim, I make the following incidental and consequential provisions which appear to me to be necessary or desirable for giving effect to the objects of this proclamation, namely, I'll come straight to 2, the operation of the following provisions of the Constitution and of the state constitution is hereby suspended, namely, so much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article. And then so much of clause 2 of Article 151, etc. But I'm concerned with this part in particular. So much of the first proviso to Article 3 of the Constitution as relates to the reference by the President to the legislature of the state, and the second proviso to that article. This is now referring to the Constitution as extended to Jammu and Kashmir, because there are 2 provisos in Article 3, which were introduced by the 1954 presidential order.
Just one thing, Mr. C. Singh, the word used over here is suspended.
I'm sorry?
The word used over here is suspended.
Suspended, that's right.
It's not.
No, suspended. Now, we are talking about a presidential proclamation where the Constitution has not been able to be worked on the report that the President has presumably got from the governor, etc. And therefore, there's a presidential proclamation under 356.
No, I specifically drew your attention to this because you said that while referring to the 4th argument of yours, the 4th contention of yours, you use the phrase that in case there is possibility of misuse.
By suspending and then changing the nature of the state.
Please continue the argument.
The suspension becomes like an obliteration. If you suspend a requirement to consult the people of the state and then change that state into a union territory, that suspension it's an obliteration virtually. It doesn't. It might not make any difference whether we call it a suspension or obliteration.
Are you approaching it from the perspective of Article 356, that the power under Article 356 cannot be used to achieve these ends, such as the suspension? I mean, how are you further exploring the point?
Yes, unless this was in furtherance of the object of 356 and it pertained to a body or authority of the state. Here, the suspension is of a constitutional provision which deals with consultation with the representative body of the state, which is the legislature of the state, the legislative assembly of the state. Now, this can't have any, even the remotest nexus with an Article 356 object. To suspend consultation with the legislature of a state, or even, I'm now arguing against myself, or even the substitute for that legislature, which is Parliament, to suspend that consultation altogether, can't have any nexus with the object of 356. 356 is for the purpose of, because the constitution hasn't been working in that state, or the state isn't able to be governed as per the constitution, and therefore there's a temporary suspension. And your Lord, I don't want to go into repeat arguments on 357.
The argument on your side has been that 356 is for the purpose of restoring democracy, not for abrogating. That was the argument.
That's right. And this, unless the union were to tell your lordship when they start their arguments, whenever they do, unless the union is to tell your lordship that yes, it was an object of Article 356 to change Jammu and Kashmir from a state to a union territory, they can never justify this as having any nexus with the object of 356.
Therefore, there are two distinct arguments, therefore. One, whether the power under Article 3 can at all be utilized to convert a state into a union territory. That's one.
That I'll come to subsequently.
And the second, whether this power was correctly utilized or constitutionally exercised at a time when Article 356 was in operation. Does Article 356 empower the union to do this?
That's right. But
there are two different areas which we would like to hear from you very briefly.
I'm very grateful to my Lord the Chief Justice, but this is one step before that. I'm saying that if you read, it says, make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operations of any provisions of this Constitution relating to any body or authority of the state. So my argument here is, one, such the para C2 can never even remotely be for giving effect to the objects of the proclamation. On 18th of December or 19th of December 2018, the object of the proclamation was not for changing the status of Jammu and Kashmir. And if it were, then it's a fraud on the Constitution. It's an absolute fraud on the Constitution if you admit that this had a nexus with your object on 18th of December.
In fact, to stretch your argument could be that the object of any proclamation under Article 356 can only be to ensure that the government of the state is carried on in accordance with the provisions of the Constitution.
As a stepping stone to restore full democracy in that state. I bow to your Lordship, I couldn't have put that better, very neatly. And I am very happy to adopt that line as my own. Now, in this behalf, if your Lordship will state away, I'll rather than take your Lordships into Bomai, in my Lord's, the Honorable Chief Justice's judgment in opinion in Krishna Kumar Singh, if my Lords are kind enough just to see that what is the judicial scrutiny required on a proclamation, presidential proclamation, volume 21 of the case law compilation.
Page?
At PDF 61, PDF 60, I'm sorry, because your Lordships have...
Which volume, Mr. C?
Volume 21, PDF 60, paras 55 and 56. Your Lordships have set out...
this is 7 judges, right?
Yeah, my Lord's judgment was 7 judges, and your Lordships have just extracted a very apposite portion from Bomai.
Page 60. Which page?
PDF 60. in volume 21 of the case law compilation. Your lordships have it?
This one.
Look at the foot of that page, Placetum G, just one line above Placetum G, elucidating the approach of the court when a proclamation under 356 is questioned. Justice Jeevan Reddy held in Bomai case, para 373, whenever a proclamation under 356 is questioned, the court will no doubt start with the presumption that it was validly issued. But it will not and it should not hesitate to interfere if the invalidity or unconstitutionality of the proclamation is clearly made out. Refusal to interfere in such a case would amount to abdication of the duty cast upon the court, Supreme Court and High Court by the Constitution. The standard of judicial review was formulated in the following observations, Bomai case, para 374, and the truth or correctness of materials cannot be questioned by the court, nor will it go into the adequacy of the material. It will also not substitute its opinion for that of the president. Even if some of the material on which the action is taken is found to be irrelevant, the court would still not interfere so long as there is some relevant material sustaining the action. The ground of mala fides takes in inter alia situations where the proclamation is found to be a clear case of abuse of power or what is sometimes called fraud on power, cases where this power is invoked for achieving oblique ends. I'm confining myself to C2. I'm not, others before me have argued on the larger issue, but since I'm on the State Reorganization Act alone, I'm just keeping it as narrow as possible. C2, I submit, is clearly beyond the purview of the 356, and except for revealing the underlying intention of that proclamation, it does nothing more. C2. Nonetheless, in Rameshwar Prasad, a constitutional Chief Justice Sabarwal, then speaking for the bench in Rameshwar Prasad, at volume 3, PDF 96, if my lords are kind enough to come to that. Actually, PDF 95.
But, Mr. Singh, is the conversion of the state into a union territory, is it severable from the abrogation of 370 itself?
Yes, yes, it is. It is. The two are completely separate. Here, what has happened is that are relying on Article 3. They have by passing a simple law, simple parliamentary law under Article 3, a State Reorganization Act was passed. And
so your argument on the conversion of J&K into the two UTs, that would really survive irrespective of the decision on the abrogation of 370.
My submission starts with that this is completely independent of the abrogation. Whether J&K was from day one completely under the Constitution of India with no commas and full stops taken out of it, whether it was under 370 as applied to J&K, with any permutation.
Even if you were to exercise this power according to you in relation to any Indian state,
that's right,
this would be unconstitutional.
That's right.
Irrespective of the special considerations which apply to J&K in relation to 370.
Yes, yes, and irrespective of the proviso also, the scheme of Part 1 and read with Article 368, and I'll show you, Lordship, it completely precludes such an exercise. Also, when I come to the history, your Lordship will find that all right from the 1919 Government of India Act, 1935 Government of India Act, the precursors to Articles 3, 4, and 368, and then the Constituent Assembly debates, and then what came about. This was never the powers given to the Crown initially, to the Governor General in 1919, to the Crown in 1935, and to the Parliament in 1950, were powers meant to mediate when a minority, perhaps in a state, made out a justifiable case for greater self-representation. Suppose there's a linguistic minority in a state, but they have a distinct area, like Haryana was in Punjab or Himachal was with merger of princely states. The idea, or let us say there's certain other reasons where there are people who can't get a majority in that state assembly to accept, but they make out a case for greater autonomy, greater representation, for full statehood. Parliament under Article 3 and 4 acts as a mediator. Because
how were the UTs born in
yes,
the Republic?
I'll come to that.
I think in my judgment in NCT 2, I've dealt with the whole history of how the UTs were created.
You have. But
and were the UTs, in other words, was there a peculiar constitutional history attached to the creation of UTs?
Yes.
And does that category remain frozen now?
In fact, that category has moved consistently towards full statehood. By the 4th of August 2019, there were only
the origin of the creation of UTs.
Yes.
Then?
But look, may I?
We'll have to then, because your argument will have to explore in this way. What is the history surrounding the creation of union territories under the Indian Constitution? Yes. 2, does that category then remain a sort of frozen category in the sense that you can convert a UT into a state, but you can't do the reverse process? That's the second point.
And that is historically, that is what has happened. So by 4th of August 2019, there were 7 UTs left in India. And they were Delhi, Chandigarh, Delhi, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, Puducherry, Lakshadweep and Andaman. All other UTs were gradually, once they could become viable units, the moment an area could become a viable unit as a state, it was converted into a state.
What do we find? I mean, how were the UTs created?
Yes. So, look, can I just then give your lordship the pages for this first argument? Just so that...
yes, certainly. And then we can move to the next.
You're
on Rameshwar Prasad until I...
Rameshwar Prasad, look, volume 3, page 95, PDF 95. Para 96. Here, my Lord, Justice Agarwal spoke for the bench. It was a unanimous verdict of the Constitution bench.
And what is the principle which Justice Agarwal has laid down there in para 96?
On the nature of the power under 356 and the nature of the scrutiny, he goes a step further beyond Lord Bomai. I'll only take your lordship very pointedly to the short 3 or 4 important paras. 96, Justice Agarwal says the power under Article 356(1) is an emergency power, but it is not an absolute power. Emergency means a situation which is not normal, a situation which calls for urgent remedial action. Article 356 confers a power to be exercised by the President in exceptional circumstances to discharge the obligation cast upon him by Article 355, which Mr. Nafde pointed to. It is a measure to protect and preserve the Constitution. The governor takes the oath prescribed by 159 to preserve, protect, and defend the Constitution and the laws to the best of his ability. The power under 356 is conditional, the condition being the formation of satisfaction of the President as contemplated by 356(1). My submission is that this applies equally to 356(2). And when the President is satisfied that certain measures need to be taken to fulfill the object of the proclamation, that also must meet the same test. Then para 97. There's an extract from Bomai in para 97 of the foot of that page. When the proclamation is challenged by making out a prima facie case with regard to its invalidity, the burden would be on the union government to satisfy that there exists material which showed that the government could not be carried on in accordance with the provisions of the Constitution. Since such material would be exclusively within the knowledge of the union government in view of the provisions of 106 of the Evidence Act, the burden of proving the existence of such material would be on the union government. And then, my lords, next para, overleaf, PDF 96, in para 98, just placidum C may be seen. if and when, this is Justice Jeevan Reddy's opinion in Bomai, if and when any action taken by the president in exercise of his functions is questioned in a court of law, it is for the Council of Ministers to justify the same, since the action or order of the president is presumed to have been taken in accordance with Article 74(1). And then 324, para 324, at the foot of that page of Bomai, in our respectful opinion, the above obligation cannot be evaded by seeking refuge under 74(2). The argument that the advice tendered to the president comprises material as well, and therefore calling upon the Union of India to disclose the material would amount to compelling the disclosure of the advice is, if we can say so respectfully, to indulge in sophistry. The material placed before the president by the minister or council of ministers does not thereby become part of advice. Advice is what is based upon the said material. Material is not advice. And I won't trouble your lordships. And then para 100 is very important. Overleaf at page 97. The above approach shows objectivity even in subjectivity. Constitutionalism or constitutional system of government abhors absolutism. It is premised on the rule of law in which subjective satisfaction is substituted by objectivity provided by the provisions of the Constitution itself. This line is clear also from Maruram. And look, then if your lordship would just come to PDF 120, PDF 120, paras 138 and 140, they're very short paras. PDF page 120 of the same volume, volume 3, paras 138 and 140. 138, clearly Bomai case expanded the scope of judicial review. True, the observations of Justice Reddy were made in the context of a situation where the incumbent chief minister is alleged to have lost the majority support or the confidence of the House, and not in the context of a situation arisen after a general election in respect whereof no opinion was expressed. But in our view, the principles of the scope of judicial review in such matters cannot be any different. And then para 140, thus it is open to the court in exercise of judicial review to examine the question whether the governor's report is based upon relevant material or not, whether it is made bona fide or not, and whether the facts have been duly verified or not. The absence of these factors resulted in the majority declaring the dissolution of the state legislatures of Karnataka and Nagaland as invalid. And lastly, my lords, Madhav Rao Sindhya in volume 6, Volume 6, PDF 457. Para 111, I think, has been shown to your lordships by Mr. Nafde, perhaps. But para 113 at page 457 is very important. Volume 6, PDF 457. Para 113. 113. By express injunction in Article 53(1) of the Constitution, the executive power vested in the President is directed to be exercised in accordance with the Constitution. That power is intended to be exercised in aid of and not to destroy constitutional institutions. Granting that power to recognize a ruler carries with it the power to withdraw the recognition of the ruler. The power must be exercised bona fide and in the larger interest of the people, consistently with the provisions of the Constitution to maintain the institution of rulership. Power may therefore be exercised in the course of and for recognizing another person as a successor to the ruler, having regard to the laws and customs governing the state. The president is not competent to recognize a person as a ruler who is not by the custom and law qualified to be a ruler. The president cannot obviously withdraw recognition of a ruler and recognize another, nor can he lawfully depart from laws and customs of the state to introduce a person as a ruler who is not by ties of blood, etc., etc. Now, the next page, the overleaf, 458, the fourth line, but unquestionably, the president is not invested with arbitrary authority to recognize a stranger as successor to the Gaddi or not to recognize any person at all as a successor. The power of the president is plainly coupled with a duty to maintain the constitutional institution, the constitutional provisions, the constitutional scheme, and the sanctity of solemn agreements entered into by the predecessor of the union government, which are accepted, recognized, and incorporated in the Constitution. An order merely de-recognizing a ruler without providing for the continuation of the institution, which is an integral part of the constitutional scheme, is therefore plainly illegal. Look, Madhav Rao was a judgment of a bench of 11 learned judges, and Justice J.C. Shah, His Lordship Justice J.C. Shah was speaking for 7 of himself and 6 other learned judges, for 7, the majority of 7. I think there were some concurring and some dissenting opinions. But I'm just placing this that these powers have to be exercised bona fide, and I don't see anything, certainly not in their counter, but there's no justification whatsoever for why these two provisos had to be suspended and what nexus that would have with the proclamation under 356. That's the first point. Now, may I just skip over the second point, that timeline? I'll come back to that. I've made just a one-pager where I set out that timeline. I can come back to that since the question fell from my lords about the background to union territories and how they came about and so on, and what is their status in the constitutional scheme. Yeah. So this is if your lordships are kind enough to see what happened, was I'll just summarize it and I'll take your lordship straight to the relevant provisions. 1905, Lord Curzon, my lords, split the province of Bengal. This was done unilaterally as a Governor General. That led to the partition or bifurcation of Bengal, led to a tremendous backlash against the British Raj. And there were huge protests, a lot of killings, etc., etc. And ultimately, in 1911, Lord Hardinge was compelled to rescind that move and restore Bengal as one province. Now, this experience led to a declaration by the British Parliament on 20th of August 1917 to devolve greater power on India, and particularly on the provinces of India and the representatives of the people in those provinces. And this, your lordships will find, the declaration by Parliament led to the 1919 Act, the Government of India Act 1919, which specifically provided for the original precursor to Article 3. So the 1919 Act, along with that declaration, your lordship will find, volume 18 of the documents, and it's that proclamation, that declaration is very important, lords, and as also the preamble to the 1919 Act. Volume 18, page 14, PDF 14, is the declaration of 20th August 1917.
Volume 18, page?
Volume 18, PDF 14, is the declaration of 1917, 20th August 1917. It's very short. May I read it, please? The policy of His Majesty's government with which the Government of India and complete accord.
Have you got it?
Page 14. I'm so sorry. Volume 18.
The Government of India Act 1919, right? Yes. We have section 3 there, 3.1.
Yes, but the declaration is at PDF 14. The declaration of 20th August 1917.
No, that's not at page 14.
Page 14 is the Government of India Act.
Volume 18 lives PDF 14.
No, that's 10849, which is the page you're getting.
10835.
Oh, 10835.
Yes, I don't know why my PDF. Oh, there must have been an earlier version. I'm so sorry. 10835. Does anybody have the correct page?
53.
What page is it?
I had it at PDF 14 because that was what was given to us.
10835.
The declaration
of 20th of August PDF.
Declaration of 20th August 1917.
The PDF.
It starts with the policy of His Majesty's government with which the Government of India are in complete accord.
PDF page 14, yes, it's there.
We all have it as PDF 14. I think that
yes, 835, right? It's 10835.
10835. And on this side, we all seem to have it at PDF 14. I don't know, there's some mismatch. My lord, find it now.
Yes, just one thing. From Yalapura?
Yes. This is, no, this is from extracted, all this entire book is here in this volume, which is the Working Constitution in India by S.M. Bose, the 1921 publication.
Yes.
The policy of His Majesty's government, with which the government
Just one, Mr. 1 second.
Yes, Prasanna. My Lord, Honorable Justice Suryakant finds it. You have a problem with PDF 58 also about the section. Perfectly matched. There's some. We could, I could hand up an iPad if for my lord. Your Lordship, 10835, the running page. The declaration of 20th August, the policy of His Majesty's government, with which the government of India are in complete accord, is that the increasing association of Indians in every branch of the administration and the gradual development of self-governing institutions with a view to the progressive realization of responsible government in India as an integral part of the British Empire. They have decided that substantial steps in this direction should be taken as soon as possible, and that it is of the highest importance as a preliminary to considering what these steps should be, that there should be a free and informal exchange of opinion between those in authority at home and in India. His Majesty's government have accordingly decided, with His Majesty's approval, that I should accept the Viceroy's invitation to proceed to India to discuss these matters with the Viceroy and the Government of India, to consider the Viceroy views and the views of local governments, and to receive with him the suggestions of representative bodies. I would add that progress in this policy can only be achieved by successive stages. The British government and the Government of India, on whom the responsibility lies for the welfare and advancement of the Indian peoples, must be judges of the time and measure of each advance, and they must be guided by the cooperation received from those upon whom
Mr. Singh, what is the relevance of this actually?
Then, Your Lordship, just see the preamble. I'm sorry. The progress, when Your Lordship sees the particular section, the preamble then was based on this of the Act in 1919, was 5 pages down. If Your Lordship just scrolls down 5 pages to the Government of India Act. Now, the preamble to the Act specifically said the 1919 Act, whereas it is a declared policy of Parliament to provide for the increasing association. So, based on this same declaration, there was the
were the
union,
union,
then
were the UTs all were the UTs all a part of the Part C territories?
So I'm just coming to that provision then straight away. If Your Lordships, I have it at PDF page 58.
And before the Constitution came into force, where were these Part C territories comprised?
Yeah, so there
They were the chief commissioners provinces.
yes, that's right. So there were the governors' provinces became part A states. The governor general and then later the governor. So Bombay province, Madras province, Calcutta, Fort William, etc., became the part A states. The Indian states, which
became part B.
Not all of them, there were 562 states, those which could be merged and made into viable states, because viability was the main crux here.
But J&K was also a part B state.
That's right. So those which were viable as states, all Indian states which were viable either standing as they stood or by merger, became part B states. Those which were
now in the Government of India Act, what was the classification of the territories in the Government of India Act?
Yeah, that in the Government of India Act, there were governors' provinces, there were chief commissioners' provinces, and I'll just show that.
So we must look at what was the position in the Government of India Act.
That's right.
How that transformed into the Constitution.
Yes.
So that will give us an idea of how the Union territories were created.
Yes. And in fact, in the
Union territories came into being. One thing is very clear: the Union territories came into being with the 7th Amendment in 1956.
So in the 7th
that
Amendment,
abrogated the distinction between Part A, Part B, and Part C states and the Part D territories.
Yes.
And then brought the entirety of India into the states and the Union territories.
Union territory. Now, so I'll just show your lordship the progression. So if your lordship sees here, the please come straight away to PDF 58, which would be in this same volume. It's 10879 running page.
Page 58.
But your 58 won't match because 14 wasn't matching. Could your lordship tell me what was your equivalent PDF for 14?
The difference is 14 pages actually.
14 pages, 14 more. So this 58 would be 72, perhaps around 72, 1087. 10879. It should be a PDF 72 if there's a difference of 14 pages.
How does it start?
Section 14 is on the top. Government of India 10879 is the running page. The printed page number is 44 and it's PDF. We have PDF 58, all of us here.
PDF 72 is 10907.
109?
PDF 44.
Oh, it's 14 less then. So it should be 44, perhaps PDF 44. PDF 44 should work out. 43
you're referring to internal page 44. PDF is 58. Section 14 you're referring to.
Yes,
14, right?
We are getting PDF 58.
That is 10879.
Yes.
That is page 44, I think.
No, that's page 44.
Yeah.
PDF is page.
So your lordship's PDF is matching the internal page number, I think.
No.
So now 15.1. Page. What I'm taking your lordships to is the precursors to Article 3. But to answer the union territory aspect, in my written submission, your lordship will find that.
So now we are at 10879 with a great effort. So let's focus on that. We don't lose this precious page.
So this is the precursor to Article 3 in the 1919 Act, Section 15.
Section 15.
Yes.
All right, let's see that.
And the marginal note is constitution of new provinces, etc., and the provisions as to backward track. The Governor General and Council may, now please note, after obtaining an expression of opinion from the local government and the local legislature affected. This is why I was reading that preamble and the declaration of the of the king, His Majesty. The Governor General may, after obtaining an expression of opinion from the local government and the local legislature affected by notification with the sanction of His Majesty previously signified by the Secretary of State and Council, constitute a new governor's province or place part of a governor's province under the administration of a deputy governor to be appointed by the Governor General, and may in any such case apply with such modifications as appear necessary or desirable all or any of the provisions of the Principal Act or this Act relating to governor's provinces or provinces under a lieutenant governor or chief commissioner to any such new province or part of a province.
Therefore, that is the power to constitute a new governor's province.
Yeah.
Yes.
And then subsection 2 deals with backward tracks. We are not concerned with that. This was then carried forward in section 290 of the 1935 Act.
Where is that?
That your lordships will find. Look, I'm sorry, in this, could your lordship just read the footnote to this? Section 15, there's a footnote of the committee report, which is very important. This is in the whole thing of self-governance. The footnote is on the next page. For constituting, the committee have two observations to make on the working of this clause. On the one hand, they do not think that any change in the boundaries of a province should be made without due consideration of the views of the Legislative Council of the province. On the other hand, they are of opinion that any clear request made by a majority of the members of a legislative council representing a distinctive racial or linguistic territorial unit for its constitution under this clause as a sub-province or a separate province should be taken as a prima facie case on the strength of which a commission of inquiry might be appointed by the Secretary of State, and that it should not be a bar to the appointment of such a commission of inquiry that the majority of the Legislative Council of the province in question is opposed to the request of the minority representing such a distinctive territorial unit.
Now, where is
this is that what I was saying about the arbiter, Parliament being an arbiter when there is within a state.
Where is the Government of India Act, section 290?
290, your lordships will find in volume 6, my lords, of the document. PDF 113, and I trust, Lord, this time we'll all be on the same page, Lord. Volume 6.
Volume 6.
Page?
Page 113, Lord. 290 is almost in the same form in which Article 3 came to be enacted by the Constituent Assembly.
What is the page?
Your lordships have page 113, Lord, PDF 113.
113.
Volume 6, no, document volume 6. Creation of new provinces and alteration of boundaries of provinces.
Which is the, and how are the provinces distributed under the Government of India Act, actually?
Section 5 of this.
Yeah. 5 refer to? What is the PDF page for page?
PDF page 18, I'm very grateful to Mr. Shankarnaran.
18.
Yes, Proclamation of the Federation of India, PDF 18 of this same volume 6 minutes. Establishment of Federation and Accession of Indian States, Proclamation of Federation, it shall be lawful for His Majesty. May I read that? If an address in that behalf has been presented to him by each House of Parliament, and if the condition hereinafter mentioned is satisfied, to declare by proclamation that as for they therein appointed, there shall be united in a federation under the crown.
No, but it's kind of important because it says it shall comprise of the provinces, hereinafter called the governor's provinces, and the Indian states which have acceded or may thereafter accede to the federation. And in the federation so established, there shall be included the provinces hereinafter called the chief commissioner's provinces.
That's right. Then the conditions referred to is that states the rulers whereof will in accordance with the provisions contained in part 2 of the first schedule be entitled to choose not less than 52 members of Council of State, and the aggregate population whereof as ascertained in accordance with the said provisions amounts to at least one half of the total population of the state so ascertained, have acceded to the federation, then the manner of accession is in section 6. And the footnote notes to section 5. It says section 5 was substituted as follows. This is not the after 15th August 1947. I think this was in 1948.
This is important.
Government of India Act was.
So with the Indian Independence Act, we got the governor's provinces, the chief commissioner's provinces, the Indian states in the manner hereinafter provided, and any other areas that may be with the consent of the dominion included in that dominion.
Yes, and this was not under the Indian Independence Act. This was an amendment to the Government of India Act 1935.
Right. Following the Indian Independence.
Following the Indian Independence Act, absolutely. Because till then it was only the British Parliament which could enact the law. After 15th August 1947, the amendments were made by the in the Dominion by the Dominion.
Now, were the chief commissioners' provinces referred to in any schedule to the Government of India Act or no?
Chief commissioners' provinces, no, I think it's in the 1919 Act, but check in the 1990. Check it. Page?
Page 49.
Oh, of this very thing?
Oh, I'm very grateful. Part 4, the Chief Commissioner's Provinces, correct. At PDF 49, my lords, have that? Section 94 onwards. My lord will find this, my lord, Honorable Justice Suryakant will find it
Yes.
PDF 49.
Yes. Good.
Part 4, the Chief Commissioner's Provinces. The following shall be the Chief Commissioner's Provinces, that is to say, the heretofore existing Chief Commissioner's Provinces of British Baluchistan, Delhi, Ajmer, Merwar, Kurg, and the Andaman and Nicobar Islands, the area known as Pant Piploda, and such other Chief Commissioner's Provinces as may be created under this Act. Aden shall cease to be a part of India. A Chief Commissioner's Province shall be administered by the Governor General, acting to such extent as he thinks fit through a Chief Commissioner to be appointed by him in his discretion. Then British Baluchistan is set out in 95.
Now from here we go to the Constitution. Would it be correct to say that when the Constitution is adopted on 26th of January 1950, the territories were comprised into Part A states, which comprised of the governor's provinces, the erstwhile governor's provinces. Part B states, which were the Indian states which had acceded to the Dominion of India. Part C states.
Only such of those which were viable.
Right, we're not now on the Jammu and Kashmir thing at all. We're now looking at the broad.
Yes.
So this argument is independent of the J&K issue.
Yes.
Part C states were the erstwhile Chief Commissioner's provinces.
Yes. And
Part D states were the other territories.
No, and Part C states also had one more category.
Let's look at the Constitution as of 26th of January 1950, because that schedule will give us the distribution between what was Part A, what is Part B, Part C, and Part D.
Just one qualification.
That holds the Part C states had the Raj Pramukh.
That's right.
I think Part B also had the Raj Pramukh. Part C had the Raj Pramukh. Part A had the governors.
That's right.
And that continued from 1950 to 1956.
That's right.
56, following the Fazal Ali Commission, everything is abrogated and you just have states and union territories.
That's right. But just one small qualification. Part C states also included Indian states which were not able to be merged into a viable unit. So, for instance, Himachal Pradesh was consisting of 30 Indian states, 30 small Indian states. But because the province of Punjab, the governor state of Punjab came almost to the edge of Shimla at that time, there were hill areas of Punjab, and they automatically went as a part A state. So Himachal Pradesh with its 30 states acceding and merging into it still was not viable. So it was a Part C state, though it was Indian states, but Part C. So there were several such cases of those which were not viable as independent state for independent statehood at that point in time. It became a Part C state. It became a union territory in 1956. Then in 1966, when Punjab demanded a Punjabi Suba, and there was a huge movement and agitation, etc., as a negotiation to give Punjab a linguistic state, Haryana was carved out, and the hill areas of Punjab were carved out and given to Himachal. It still continued temporarily as a UT, and in 1971 it was made into a full state.
Now, do we have the constitution, just to complete the whole exercise?
Yes.
The constitution as of 26 January 1950, where is that?
Yeah.
They can put it on the screen.
All right, they'll put it on the screen actually.
If your lordship, in the meantime, may I just very quickly take your lordship to my written submission, a very brief thing on how this transition took place, page 468 of my written submission.
So, Mr. C, you're saying at the time when Punjab, the division of Punjab took place, there were two union territories. Himachal Pradesh was carved out as a union.
And Chandigarh.
And Chandigarh was carved
Because
out.
of common, because of the.
Correct. There were two union territories
right.
which were carved out.
That's right. That's right. Absolutely, your lordships are right. In fact, this is all in my note, but even in the written submission. But the point here is, right from the 1919 Act, the progression has been consistently and continuously towards greater self-governance, and greater self-governance in the form of full statehood.
We are only on the today for that. The question is legality of that order in terms of Article 3.
That's right. That's right. So, but the context in which the reading that I would seek to persuade your lordships to adopt is one which would be consistent with that objective of greater self-governance. When we read Article 3 as opposed to Article 368, that greater self-governance and the move that, because keep in mind that barring these small, unviable or special status union territories, Delhi, Chandigarh, Andaman and Nicobar, Dadra and Nagar Haveli, etc., by 4th of August 2019, there were only 7 union territories left in India. And the 7 were Delhi, Chandigarh, Andaman and Nicobar, Dadra and Nagar Haveli, Daman and Diu, and Puducherry and Puducherry. These were the 7 union territories left. All others were merged or amalgamated.
Now see what they have put up on, it's very interesting. Part A, this is on the date of the constitution. Part A states are basically 9 states. Assam, Bihar, Bombay, Madhya Pradesh, Madras, Orissa, Punjab, United Provinces and West Bengal.
That's right.
Now let's see Part B, thoda sa scroll kar lijiye.
Part B.
We get this.
ये कहाँ से मिला आपको?
Part,
अच्छा, गोपाल के.
Part B states,
Now Part B are Hyderabad,
Jammu and Kashmir, Madhya Bharat, Mysore, Patiala and the East Punjab states, that's the PEPSU, Patiala and East Punjab States Union, Rajasthan, Saurashtra, Travancore, Cochin and Vindhya Pradesh.
Right.
Then your lordship sees the territories of the state. The territory of each of the states in this part shall comprise the territory which immediately before the commencement of the constitution was comprised in the corresponding Indian state, and in the case of each of the states of Rajasthan and Saurashtra shall also comprise.
जम्मू एंड कश्मीर का टेरिटरी देख लेते हैं क्या है. थोड़ा सा ऊपर चलिए और जाइए ऊपर, थोड़ा नीचे, नहीं ऊपर ऊपर.
Now your lordships will see that some of those commissioners' provinces were merged into Part B states because they became viable. Fipoda.
हाँ वही पर. Ajmer, Bhopal, Bilaspur, Cooch Behar, Coorg, Delhi, Himachal Pradesh, Kutch, Manipur and Tripura.
Himachal Pradesh was at that time also?
Part C में था.
Was it not included in Punjab? It was later on included in Punjab.
And ऊपर जाइए थोड़ा सा.
Punjab was
now, if your lordships come to Part C state,
the second paragraph of each of these parts in the schedule describes what they were earlier. If your lordship sees Part A, Part B, Part C, they have explanations below the list. No, it's there. It's
yes.
Part of this.
If your lordship just goes below Part B, territories of states.
Below the list, these territories, they have for each of the parts. Now, the second explanation there describes where they came from.
Beneath each of the lists, the territories are given, and that shows how different units were merged into them even on the beginning of the constitution. I have also got a table in my
and Part D only comprised of Andaman and Nicobar.
Andaman and Nicobar, which was a chief commissioner's province in the 1935 Act. But that was carved out separately.
So Ladakh is a UT, and the change of status from a state to a UT of Jammu and Kashmir.
Yes, Lord.
Both aspects.
Both. First of all, just the conversion of a state into a union territory, I submit, is only if at all it could be done. I submit it violates the basic structures. It can't even be done under Article 368. But if at all it could be done only under Article 368 because it clearly impinges on at least 6 or 7 provisions in the proviso. So it would require both the special majority and ratification by more than the legislatures of more than 50% of the states to convert a state into a union territory, and I'll make good that submission.
Therefore, I refer to two different things. Carving, the change of status is one, and suppose Jammu and Kashmir assembly status was maintained and only UT was carved out, then what could be argued?
Even so, the submission really is that for Ladakh and for Jammu and Kashmir, the exercise which has been done is one which is clearly beyond the purview of Article 3. It was not permissible under Article 3 at all, even if it had been rightly done. I'll show from the timeline that it's actually not even done as per Article 3. But assuming it were rightly done under Article 3, this is not the scope of the power of Article 3. When I take your lordships through the provisions of the Constitution, your lordship will see Article 295, Article 294, etc. A state comes with property or lands, property, consolidated fund, rights, contracts, right to raise money. It has absolutely sacrosanct powers under Article 73, read with Article 162. The executive powers, the legislative powers.
Your 1 hour, how long would you now take?
Look, I'll try to be as brief as possible. I think it will take about an hour or so.
No. 1 hour, no, Mr.
Look,
can't be 1 hour. Can't be.
I'll tell you also, this is what I'm arguing is something nobody else has argued, but the main thing here is we are saying that regardless of what
is the point of this chart then?
Look, independent.
You're supposed to have a kind of arguing discussion.
Look,
in 1 hour you take 2 hours, then this schedule means nothing.
Look, I acceded to your lordship wishes and I confined myself from day one. I adopted other people's arguments. I'm not touching on 370 at all. I'm saying that and if at any stage your lordship feel that I'm going beyond the purview of there are the 4 or 5 points which I outlined at the beginning.
You've made your 4 points, but you have made your 4 points now, and your argument really is this. That look, insofar as they're twofold, you cannot convert an area which is comprised in a state into a union territory. Now we have seen the history of the creation of the union territories.
Yes.
Because when you create a union territory, we've also, people who have preceded you, they have said that, look, the whole essence of a state is democracy. You have a legislature, you have elections, you have converted it into a union territory which has no legislature, which has no elections over the past 4 years. Therefore, that's one aspect. The second aspect,
and the large bulk
of your submission
without a legislature
the second aspect of your submission is that you can't use the Article 356 power to suspend the 2 provisos to Article 3 and then use that to complete the process of conversion of these states into union. So these are the 2 key areas, really. I think we can give you another 10 minutes.
I'll go with, look, I won't be able to do it in 10 minutes. And I think your lordship will perhaps accept my submission.
Actually, Mr. Singh, everybody has argued this point also before. Just that.
Look, I will not repeat a single argument that anybody has made. I'll take your lordship very.
3 to 3:15. We'll give you 15 minutes, I think.
Look, I'll go as quickly as I can.
Minutes and that's it. Now,
I don't think I'll be able to do that. No, then I.
Mr. Singh,
Fair to
otherwise,
say. I'll go very quickly, Manoj. I will not, take extra time on anything. I'll just go point wise and place the
because
relevant pages.
tomorrow they have to start arguing. Between all of you, we decide now, we'll give you a little more time, but it will cut into somebody else's time. So who that person is, you please decide for yourself.
No, I think that, that may not be proper in this case, Manoj.
No, delimitation, for instance, we are not concerned with delimitation here. Delimitation is not an issue in these petitions. So we have to now, the delimitation argument, Dr.
No, I'm not arguing on delimitation.
No, that's what we are trying to say is that at lunch, you reorganize the time between yourselves because delimitation will not arise at all in this.
I think your lordship may need to give us a little bit of time tomorrow, a little bit of time.
No. We'll conclude today of all this side, yes.